Thanks so much for attending today. We're going to boil down some of the complexities of the foreign trust from an estate and gift tax perspective, along with a U.S. income tax, some income tax perspectives and ideas and strategies, and some asset protection issues as well. We're going to take it on a step-by-step basis from both the U.S. person's perspective, the U.S. settlor of a foreign trust, and the foreign person, the non-U.S. person's perspective, so that we can kind of contrast and compare the strategies to avoid tax. On the agenda, we're going to first introduce you to how do you create a trust? What does it consist of? What is a trust? And from a tax perspective, what is a foreign trust? We're going to do an overview of foreign tax, both estate and gift and income, and then how trusts are used to avoid or are incorporated in a tax efficiency strategy, both from the US side and the foreign side. We'll first look at why US people form foreign trusts, both for estate planning and for protective purposes. And then we'll look at why an RNC, non-resident, non-citizen, uses foreign trust or can use a foreign trust for tax planning. So from an introduction, the trust is actually the original, in a sense, asset protection vehicle. In the 1400s, well, based on ownership of real estate and how assets were passed from generation to generation, it became very advantageous to divide the title of assets. In other words, if I were going off to war and I wanted to leave assets to my son essentially, let's say the son was 3 years old, could not accept title to the assets, could not manage the asset, etc. So the obvious problem was, well, women at the time could not hold title, right? And business entities had not really developed at that point. There was what began as, interestingly, the limited partnership, but that didn't really apply. That was like a Roman thing. So we got into this idea of, okay, I'm going to put title with someone who eventually became known as a trustee for the benefit of somebody else, the beneficiary. So we've said, okay, the trustee can manage the asset, can move the asset, can sell the asset. That's called legal title. They have legal title to the property, but cannot benefit from the asset, cannot take the asset for their own benefit, but only manage it for the benefit of this beneficiary. But the beneficiary, if the trust is discretionary, has no ability to reach the asset. So what happened was you created this asset that benefits someone who cannot reach it. So when that individual becomes subject to a lawsuit or some kind of a claim, that asset's not available because the claimant, the plaintiff, is suing for full title, but the beneficiary only has beneficial title. And if that trustee decides not to transfer that asset out to the beneficiary, you can't reach it. And so even today, that arrangement, the IRS calls it an arrangement, is respected. And that's how we create the trust fund baby. Everyone loves that because everyone's heard of a trust fund baby. That's the trust fund baby. So the baby can get into a car accident, but because title was divided in the 1400s, you can't reach the asset. Every state has a slightly different take on it, but that's pretty much true. That's pretty much true. There's some exceptions for child support, just marital issues in different states. But that still remains. That original idea still remains. If you make a distribution from the trust and it goes to the Benny, it's on the slide here. That's exposed. As soon as a beneficiary has full title to the asset, it's totally exposed. A lot of people ask, well, what I'd like to do when I create the trust for my child is when they turn 30, I want them to get, 500,000. When they turn 40, I want them to get 2 million. When they turn 50, you can do that. You can do that. That's absolutely available as an option. You just have to keep in mind that if you create a mandatory distribution of that 500,000, the moment it's available, even if it's not distributed to the beneficiary, the moment it's available for distribution, it's exposed, right? So that's the division of title. At the moment it's out, it's outside the trustee's discretion. If that kid gets in a car accident, that money is exposed to the plaintiff. Also, they're very confidential, these trusts. They're not publicly filed in the US. A lot of times people will come into the office needing planning, and they'll say, we need everything, but we have our trusts. They use the word trusts. So most of our assets are protected. We've titled them in trust. And it's a revocable trust. And a revocable trust is essentially a fancy will in, I think, every state now. I want to say every state. In Florida for sure. So if you have a revocable trust, you have a will. And if you title an asset in a revocable trust, you're allowed to do that. That's why you have a revocable trust instead of a will. You can title an asset in a revocable trust. It's not subject to probate. It is totally available to your creditors, though. So that's not a trust. The idea of a trust is that a grantor puts money into trust with someone for a beneficiary, right? Well, in the 1980s, a few offshore jurisdictions says, well, you can create your own trust, right? In Florida, for instance, you can't. You can't create a trust for yourself and have it protect the assets in the trust from your creditors. So that became an industry in the 80s, 90s. These trusts started to get built up. There was some tax evasion, which was kind of stupid. The trust doesn't do that. We'll get into that. But because they became so popular, this idea of protecting at your assets in your own trust, 20 US states now have a statute that allows you to protect assets for yourself in your own trust. They have different requirements, but essentially you have to appoint a trustee in that jurisdiction and form the trust there. And then it's a different seminar, but you really want to try to create contacts to that jurisdiction to make sure that that arrangement is protective. From the tax side, essentially you're going to be looking at whether the trust is a domestic trust or a foreign trust because the compliance totally changes. Many of the tax provisions actually change as well, the actual taxation of the trust. And so what we look at, what the IRS says is in the code, if a court has authority to bind the trust, a US court, right, in the terms of the trust, a US court, you can sue there, a US court can interpret the terms of the trust and bind them on the parties associated with that trust. And a US person manages the trust, which essentially means that you have a US trustee. So if the US court can bind it and you have a US trustee, you don't have a foreign trust. If either though you have a foreign trustee or a US court cannot bind the trust, typically, generally speaking, that's if it's formed in another jurisdiction. Or an uncle from Holland who your grandpa knew is the trustee and doesn't live here, right? Is not a US citizen, that's a foreign trust. So all of that compliance and regulatory framework will now apply to that trust. Just so you get an idea of what's a foreign trust and what's not a foreign trust. Now we'll go into just the general estate and gift and income tax side of trusts. and particularly foreign trusts. After that, what we'll do is we'll break down why people in the US would do a foreign trust and why people offshore would do a foreign trust. So as background, I know we have actually a lot of people are attending today, which is great. We have a lot of CPAs and a few tax lawyers on the line. I know this may be repetitive, but many of the people on the webinar don't have that much background, and I think it's very helpful. So we have both an estate and gift tax. So we're taxed when we give, and we're taxed during life, and we're taxed when we make gifts at death, but only above a credit. That credit is for about 14 million per person now, which is the highest essentially in history. Actually, it's by far the highest in history. And next year, since the big beautiful passed, it will be 15 million. So that's a 30 million per couple. So the estate tax doesn't come into play until you've given away during life and at death more than, if you're husband and wife, more than $30 million, which is obviously a huge amount of money. We do have the majority of people that see us do have that tax issue, and there on the domestic side are a number of strategies to reduce that under a taxable amount. Today we're going to talk about the foreign trust as well, but that's just as background. The gift tax is not done, obviously, at an amalgamation of all your estate when you die. It's done every time you make a gift. So every time you make a gift, you've got to tell the IRS if it's more than $19,000, and it chips away at that 30 million. There are ways to get discounted values on those gifts, different seminar, but that there are gift tax strategies as well, unrelated to this foreign issue we're going to discuss today. So who's a U.S. person and who's a foreign person, right? So interestingly enough, almost no one, even this is not an insult, but because most CPAs don't deal with international tax, most CPAs are not exposed to the idea that a U.S. person taxed on worldwide income or worldwide estate assets, worldwide, there's a different standard to determine whether you're U.S. and you're talking about estate and gift tax or income tax. So on the estate and gift tax side, are you a domiciliary? Have you gone to the States, landed there with the intent to stay indefinitely? If you haven't gone there with the intent to stay indefinitely, you're not an estate and gift tax U.S. person. You're not taxed worldwide by the IRS on your estate and gift. That's a key issue which will permeate everything we talk about today. On the income tax side, unrelated standard. If in fact you spend a certain number of days in the States, it's essentially a weighted average that you're here more than half the year for 3 years. It's a weighted average. So the current year is times 3, the prior year times 2. It's a little bit of a formula. And then there's a cocktail party rule, which everyone loves, which is you can't be here more than 120 days. I would tell you that probably half the clients that come in work off this cocktail party rule on the income tax side, 120 days, and think that it applies to their estate and gift regulatory framework. It's got nothing to do with their estate and gift tax from a U.S. perspective. On the income tax side, you're looking, if you're non-U.S., you're looking at U.S. source income. Do I have U.S. source income? If it's passive income, it's subject to a 30% withholding rate. If it's business income, it's a graduated rate. And then when we get into foreign trusts, is the foreign trust established as an independent entity? If it's independent, it's taxed like a foreign person. So it's also subject to tax on passive income on if ECI, which is income effectively connected to an active business, that's graduated rates. It's subject to FERPTA, which I'm sure many of you are familiar with on real estate. It's its own taxpayer. If it's grantor, which means that from an income tax perspective, it doesn't exist. So right now, everyone can form a grantor trust if you have certain powers in the trust, and it's taxed as if the settlor of the trust owns the assets. It doesn't impact the flow of protections or the estate tax directly, but you can pay the income tax on that trust, even though you're the settlor and it's a separate trust formed in properly formed in the US or foreign. It can be grantor. So whether it's grantor or not, depending on the status, it's going to be taxed as an independent person. If it's non-grantor, if it's grantor, it's going to pay tax just like the whoever the settlor. If it's a foreign settlor, it's going to be foreign. If it's a US settlor, it's going to be US. This is a generalized slide where we talk about the general gifts of intangibles. So one overreaching issue is if we're foreign and we have this issue of our US assets are going to be taxed when we die. If we're foreign, we don't live here, we don't work here, we're not here, and we have US assets, they're subject to a 40% tax when we die. So we have to deal with that. One way is, are the assets intangible? If they're intangible, stocks and bonds. If they're intangible, we can gift them, we'll get to however we want, get them out of our name. If US persons, we want them to own it, however we want to do it. And importantly, we can gift them to trust. There's no gift tax. If we die with that intangible, it's subject to estate tax, right? We have exception for treaties between countries. It will reduce estate and gift tax. And we have exempt assets. If you die with them, you actually are not taxed on those assets. Foreign corporation is a biggie. So the code allows, there's also, as you see here on the slide, certain debt is not taxed if you die with it. Foreign corporation is a biggie because we can create a foreign corporation and convert a US asset to a foreign asset and not have to pay tax when we die. So this is if you take nothing else away, if a foreign person forms a foreign corporation or an LLC taxed as a corporation, that corporation does not die. That corporation is not subject to US tax upon the death of the client. So number one, you want to fund your US investments in general through a foreign corporation. It will block the estate and gift tax. These are some further exceptions. Bank deposit, life insurance is not taxed as a US situs asset. So you don't need the foreign corporation for these exceptions. Here are the others, the public portfolio debt, etc. So as a non-resident, right, you're only entitled to a $60,000 estate and gift tax exemption. You have to form a foreign corporation to hold your foreign assets. There is no discussion. There's no debate. Maybe if it's grandma's got a bank account, the bank account is exempt. Maybe we don't form a foreign corporation. But if that bank account is with a wirehouse and it's actually a stock and bond account, guess what? The million in there, $400,000 tax when she dies. We want to get this stuff into a foreign holding company. We call this blocker entity. Sometimes we can use a partnership. The IRS will not rule on whether a partnership is a blocker, whether a partnership is a foreign situs entity. It's probably a foreign situs entity if we have enough connection to the foreign jurisdiction, but they won't rule on it. So we tend to use corporations. So one thing that, and then we'll probably, I'll repeat this at the end, but one thing that we have to deal with is, it's a very interesting issue I've been studying recently in some depth, is if we have a foreigner, they've properly formed a foreign corporation, they own extensive US assets of the foreign corporation, there's no US estate and gift tax issue. But they want to come over for a little while. They satisfy the substantial presence test. There's an exception to it, and they don't satisfy the closer connection. So this is something else. So they're US for income tax purposes. So you can be a foreigner, non-resident, non-citizen, foreign for estate and gift tax person, but a US resident for income tax purposes, taxed worldwide on all income. Well, that's something that someone who moves here is going to have to deal with. The income tax isn't so easy to put a blocker in. But worse than that, if you come here and you've done your planning abroad, especially with your US assets, you've gotten them out of your estate, that's done. You're US and you've got a foreign entity. Now we've got the control foreign corporation, the personal foreign investment company issues. This came a lot to light in 17 under the Trump administration, where now all of those rules were kind of fortified, and we have what's called the guilty tax, if that, if you recall all that whole process. Well, when you come in and you become an income tax resident, that's income tax, not estate tax. You're subject to all of that stuff on that foreign corp that you formed while you were foreign. It's very, very interesting, very complicated, but it's probably something you want to avoid. It's not that easy to avoid, though, because if in fact you form a foreign trust, let me see. Yeah, if you in fact form a foreign trust, most of the time on a foreign client, you want it to be a grantor trust, which means I want to create this trust and I've got assets abroad and I've got assets in the US. I've got all kinds of operations all over the world, but a lot of it is investments, and I want to benefit both US beneficiaries. I've got a kid in college there and I don't know how that's going to go. And it looks like she's going to stay, but I've got two other kids and I've got 17 grandkids that are in France, or whatever the deal. So you kind of want to operate it through this foreign trust. The issue is, though, you want it to be grantor, right? So if instead you were a US person, right, and you want to form a foreign trust, you're probably doing it for asset protection purposes. And the code says if you form a foreign trust, you're not going to get an independent taxpayer. We're not going to let you shelter foreign income abroad, because that's what foreign trusts used to be used for in the 70s. You formed a foreign trust, you had foreign stock, and that was foreign, man. That you don't touch my foreign, that's over. So now it's deemed grantor like it doesn't exist for income tax purposes, right? And if it's deemed grantor, it's not subject to section 684, which says if I form a foreign trust and I put assets in that foreign trust, those assets are deemed sold, which is a boo-boo. Like you can't throw assets in there that have any built-in gain, or like you're gonna have to pay all the gain right off the bat. But you don't. You don't. If you're grantor and you have a US Benny, either yourself or a kid, whatever, it's deemed grantor, which means that there is no sale. Deemed sale, it's like expatriation of assets, right? Until you die. Let's see what the next one. Yeah. Until you die. And if you die and those assets are part of your estate, you don't have to pay the deemed sale tax. So for US people, it's pretty straightforward. If you form an asset protection trust abroad and those assets remain in your estate, you're probably okay. That's not really true for foreigners. So what the idea on the foreign trust for non-resident, non-citizen grantor is, I want it to be a grantor trust. If I'm foreign, check the time. If I'm foreign and I've got foreign income, the last thing I want to do is bring that foreign income over to the IRS because it's not taxed by the IRS. I'm foreign, the income's foreign. So what I want to do is typically I want the trust disregarded. I want to disregard it. If I want to trust, what's really going on is I don't want to deal with my local jurisdiction in terms of forced heirship. So I want to have a foreign trust that takes care of all my kids and all my grandkids, and I want to give it to exactly who I want to give it to. I don't want to deal with my local country where I have to give 30% to the kids and 10% to this, and I don't want to do that. So a lot of foreign trusts are created with that in mind. Because remember, if a foreigner has a foreign holding company, then they're not going to have a state tax. They just use a foreign holding company. They're all set. It's the foreign trust owning that foreign holding company. Then they can kind of go generational on it and do all their estate planning through that. But they want it for tax purposes to be disregarded. Because if it's disregarded, foreign income, U.S. income, all is taxed to the grantor. And then so what the grantor can do is let's say there was a lot of foreign income, pay foreign tax or no tax or whatever the jurisdiction is abroad, and actually give those assets to a U.S. Benny. Actually give those assets to beneficiaries and have to pay a thing. But if the trust is non-grantor, in other words, it's its own taxpayer, right? And the trust makes a distribution out to a U.S. beneficiary, the kid in college, it's taxable. It's taxable income to the beneficiary. This is the yin and the yang of foreign trusts with foreigners, right? The thing about it, and we're going to get to the twist of it, is so to create a grantor trust abroad, it has to be essentially revocable or only benefit the grantor and the grantor spouse. So it's got to be kind of a nothing burger. But it's not really a great mechanism to get U.S. assets out of your estate. You don't care about that usually if you're not coming into the States because you can use the foreign corporation. If you undertake a move to the U.S., you're treated like you transferred all of those trust assets to the trust on the day you came in. Okay. That's okay because you're US and you likely have a US beneficiary. That's why you're moving there. So it's disregarded until death. If you die, if you die, you're not taxed on that tax that says you have to pay as if you sold everything. If those assets are included in your estate. This is a very complicated area. However, those assets are not, you don't want those assets included in your estate because you did all your estate planning abroad. So you get into a very complex issue, right? Coming in before 5 years becomes very complicated. You can domesticate the trust. You may be able to abandon U.S. domicile before death, but abandonment will likely cause the trust to lose its grantor status, which also will cause deemed gain on all those assets. Very complicated. On the income tax side, it's pretty straightforward. We've gone through the passive versus the active income and how that's taxed. And so we get into why US people do the foreign trust. And they do the foreign trust for essentially for creditor protection. Typically, there's no major tax advantage. We had gone through that. I'll go through this fairly quickly because I want to make sure you have enough time. We've got about 15-20 minutes to ask a few questions at the end. So I had mentioned that you have the 20 states that allow you to create your own trust, which is protective, but you have to create a connection to that trust. Here are the 20 states. Just let us know if you have a question or you want us to send you the slide deck, and we'll send it right to you. No problem. The idea is we've got a number of cases on these domestic asset protection trusts. It's really only been around for 15, 20 years now. And a lot of it comes down to, if you do the planning, you're thoughtful about it, you're not in the middle of litigation, there's no claim against you. They work pretty well. They work pretty well. We've defended several of them. We want to create a connection. We always want a trustee in that jurisdiction. I've actually had clients buy property in the jurisdiction, spend time in the jurisdiction, just to create that connection there. And also, if litigation arises, you want to try to get it into that jurisdiction, because the judges in those jurisdictions typically will respect it. But in many ways, they're untested. In this Uber case, we had an individual who filed bankruptcy. These are the two bankruptcy cases. Bankruptcy is usually a bad idea if you have assets. So all those rules change in bankruptcy. The courts have tremendous discretion, and this Uber had very little connection to Washington, Alaska. He was from Washington State. So the bankruptcy court can use what's called public policy to say, well, this is probably a bad idea. We're just going to take all the assets. And I would tell you, if you go bankrupt, that's probably what's going to happen, unless it's very, very clean. In Mortensen, he created his own trust and went into the woods to do whatever he was doing. And then he had all kinds of creditor issues and a divorce. He actually had formed the trust in a protective way, and the litigation was in Alaska, which favored him tremendously. He was beyond the statute of limitations for fraudulent transfer, where those assets can be reached and brought back out. But he filed bankruptcy and opened up a 10-year statute and lost the assets. Absolutely crazy case. In Trustco, you had a Florida case with a contractor involving a Delaware trust, and Trustco sued in Delaware, and Delaware court essentially said, you're too late. You can't. But essentially, if the court is looking at its own trust and the statute in the state says it's protected, the court's often going to protect it. These are more technical cases. There's a lot of affidavits and financials that you have to file with these self-settled trusts. It can't be a sham. You can't make it up and pretend your cousin's your trustee and you're kind of telling them what to do. In Kilker, the settlor of a Nevada trust actually was completely in the clear and started making fun of the court, so the court decided to unwind his trust. That was a crazy case. This is just some generalized mixture of the self-settled trust with LLCs is usually a great idea. Actually, obviously, we segregate properties, etc. So in case you have a problem with one property, you don't want every asset in the trust to be exposed. This is why U.S. people form these things. It's not a tax. It's not really a tax issue. Why do we go foreign versus domestic? Domestic is typically a lot easier. It's less expensive to deal with. The foreign, though, is not subject to the Full Faith and Credit Act. In other words, if I get a judgment under the U.S. Constitution in one jurisdiction, I can file it in another and collect. We've defended Nevada trust against that, but that's not available to plaintiffs offshore, obviously. And that's a weakness of the domestic trust, really. Here's some foreign trust characteristics that we put together years ago. Some of it's actually changed a little bit, but the idea is correct. They're very, very protective, and I think the most protective is the foreign trust. Some of the foreign trust issues that arise for U.S. people, there's a lot of IRS disclosure. Who will be the trustee? How do you manage the trustee? There are trustee fees. And then we have some kind of bizarre cases where people, are in the middle of litigation and they form trust, or they're hiding a stock certificate. Well, in Wells, that's the one where she's running away. They just unwound it. That was a really weird case where the court called Nevis LLC, a Florida LLC. Still haven't figured that one out. Sargent was a case that was overturned eventually where someone was playing hide the ball with stock certificates. You have to go to United Arab Emirates to find the certificate. And that was overturned where you go to jail until you produce a certificate. Yeah, in Florida. So you can't just hide the certificate anymore. You have got to do a thought out asset protection plan. And Rush University was where you're bound to give to somebody in the States. You can't just use a foreign trust to protect the assets. They'll look to all the assets in the US. Here's where you don't really respect the formalities of the trust, alter egos and a sham. It's not really a trust, and how the court can kind of put you. I'm skipping through because I want to make sure you guys get the full tax benefit of this in the next 10 to 15 minutes. So what happens is if you don't give up these assets and you haven't properly formed these trusts, you're subject to civil liability, but it's called civil contempt. So the court can actually put you in jail even though you did not commit a crime until you give up the assets. Most of these people, though, never give up the asset because civil contempt is not indefinite. They're released and essentially settle for pennies on the dollar. That's true in that FTC case, in that Lawrence case, the BB&T case. There was no civil contempt. Bill Zarian, he kind of collapsed in jail. Same idea here. So here's the connectivity. You want some connectivity to these asset protection trusts, and you'll usually be okay. And like I said, you want to combine protections. If in fact you're not able to create tenancy by the entirety, which is that marital protection where you have to have a case against both husband and wife, that's where these self-settled trusts come into play when somebody's single and they have the trust and then they divide the assets under the trust in LLCs. And that's how we combine all these protections, picking a jurisdiction. Got to be very careful with picking a jurisdiction. All the statutes differ. And I wanted to then get into why non-resident, non-citizen, these offshore individuals pick the foreign trust and how that relates to pre-immigration planning, where they decide to come in either temporarily or permanently as US citizens eventually. And essentially the goals are, let's avoid moving all these assets into the US tax net, right? Both from a potential and an actual. In other words, we definitely don't want a state tax. But do we want these assets looked at even every year by the IRS? Do we want the income, even offshore income, taxed by the IRS? We have almost no unified credit as a foreigner. In other words, there's no estate and gift tax credit. So it's really a preclusion. We want to preclude these assets from ever entering the US and protect the income. And of course, I had mentioned this forced heirship issue, which recently came up. And we can avoid that with the foreign trust. We discussed who's a US person and who's not, and it's different for income tax and estate tax. And so have you landed with the intent to stay here? That's a US estate and gift tax resident. You're subject worldwide to tax when you die on all your assets on Earth. Fortunately, it's very easy to avoid that 40% tax. You just use a foreign corporation. You know, it's interesting. Different countries know the rules. I find it, I've been doing this for 32 years. So it's essentially everyone in Brazil knows this. That they have to form a foreign corporation. And there are actually people, guys in Brazil, Brazilians, who kind of do the foreign entity and get people ready to invest in the US. We of course do a huge amount of it. And then in other countries, they're completely unaware of it. We had a situation, I think they were Venezuela, where they bought a big mansion. It's, hey, mom and dad bought a mansion and they're, 96 years old and they bought it in their own name before they were introduced to us and mom died. Uh-oh. There's no free gifts between spouses. foreign people. And so you cut the value in half, which was 3 million. They owed $1.2 million in tax for nothing. For nothing. They could have used, if they had it in a foreign entity, they would pay no tax. And so we talked about how we can move intangibles around, right? We can move intangibles around. What if we bought the real estate? Real estate subject to FIRPTA. So we can't move it around very easily. We can move it back out to a foreign entity, but is that what's called an inversion, right? Is that a FIRPTA transaction? Is it a gift? Requires a lot more planning once the mistake is made. Intangibles, a lot of people don't understand that life insurance is an intangible, so you can move that around freely. And life insurance, when it pays out, is an exempt asset as well. It's not part of your estate. A lot of people give money. If you give money within the US, it's a tangible asset. So it's not a free gift. You have to pay 40% tax on that. And it's a little complicated because the cases are a little complicated, but definitely gifts of US currency in the US. It looks like US currency outside the US may be taxable too. So you get rid of things, to the extent you can. You use up your little credit, and you create intangibles, and you can move them out. But remember this issue with real estate and hard assets. We want to create a foreign trust if, in fact, we're going to spend any time in the US. If we're going to spend any time in the US, what happens? We now have a foreign corporation, and now we're US for income tax purposes. With a foreign corporation, we're subject to this control foreign corporation issue, the GILTI tax, the personal foreign investment company. What all of those things do is they take all of this foreign income, because you have a lot of foreign clients that most of their income is foreign. They take all of this foreign income and they bring it back to the US, whether you distribute it out to the US or not. They're non-deferral structures. And I mean, that's the last thing that your offshore client wants to get involved with. The problem is it gets a little tricky. So if we can block the connection to the foreigner, even if they're here for income tax purposes, if they're offshore for estate and gift tax purposes, with a foreign trust. But it generally can't be grantor. The grantor trust means that it's disregarded for income tax purposes. Remember, we want to be grantor. There's your real estate issue. We want to be grantor because if we have foreign income, we can take all that income into consideration, right? Inside a trust that's foreign. So the US doesn't mess with it, right? So the problem is if we come into the States and we have a foreign trust, we have to wait 5 years. If we don't wait 5 years, we're deemed what? Transferring that asset out. It's subject to that deemed sale, right? If we die with that asset, it's not taxed if those assets are subject to estate tax, but we don't want those assets subject to estate tax. Deemed sale. So you have to be very careful to plan for that. We're coming up on the 50 minutes. This is that 5-year rule if you come in. The other issue that is very interesting is that when you return back, like a lot of people thought, well, we're going to abandon US income tax status, right? Well, if you abandon US income tax status, your trust is no longer deemed grantor. It may be grantor potentially otherwise, but it's no longer deemed grantor under that 679 rule. Have you then blown your deferral of the deemed sale? This stuff gets super complicated, but you have to be aware of it. You have to be aware of it. When you have the foreigner, they're going to want a grantor trust. that you're going to have to explain to them that they can't come in and become a U.S. income tax resident. They will never admit to you that they were here more than 120 days a year. It may happen. This deemed sale issue comes into play, and you have to plan for it. Now, one thing that's available is you can do a foreign trust for your foreign beneficiary grandkids, and you can do a foreign trust or a U.S. trust for your U.S. What that comes up is if you have foreign income, your foreign beneficiaries can benefit from that income without any IRS involvement. And then if you have U.S. income, your U.S. people are going to be taxed on it anyway. So you can divide it up like that. Of course, it creates strife because, if the foreign assets are worth more than the U.S. assets, etc., family issues. I know we wanted to here's the 679, 684 issue with the deemed sale. And I know we always want to be aware of treaties. So we've actually had several recent matters where we did very little planning. I know it's hard for me to even say that, but we organized their U.S. Assets, for instance, and there was a treaty, between England and the U.S., and we just went under the treaty. For instance, if you have a domicile treaty, the domicile treaty says wherever the taxpayer is domiciled, that's the only jurisdiction that will tax the taxpayer. So you don't have to deal with this cross-border estate and gift. Very important to review the treaties. I think I even have a list here. Here your estate and gift tax treaties where estate and gift tax, it avoids double taxation. Then they're just estate and just gift. Very interesting the way the politics of that works. Otherwise, for instance, if you're in South America or you're in Asia, you're except for Japan, you're basically you have to do all of this wild planning. My information's at the bottom of the last screen. I will really appreciate you attending. And I hope you got something out of it. If you'd like the slides or any of my books, just let us know. Thanks for attending.